Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready for dictation. 5 seconds. Start. Subject: Employees Provident Fund and Miscellaneous Provisions Act 1952. Extension of Provident Fund benefits to contractors' employees working for Port Company Limited regarding. The Regional Provident Fund Commissioner addressed a letter dated 4th October 2000 to the President, Port Company Limited, stating that there are several employees working for Port Company Limited under various contractors who were not getting Provident Fund benefits, and as per the act mentioned above, it is the responsibility of the principal employer to ensure the Provident Fund benefits are given to the employees, including the employees engaged by the contractors. He also stated in his letter that as per the rules in force, the contractors are not to be given a separate Provident Fund code number in view of the fact that the principal employer has the responsibility of remitting the Provident Fund contributions in respect of the contract employees. He therefore suggested that the Port Company Limited may obtain a Provident Code number from the Provident Fund Office, Vizag, so that the Provident Fund remittances of all the contract workers working for Port Company Limited can be remitted regularly in that Provident Fund code number. It is on this my opinion is sought regarding the further course of action to be taken in the matter. I have also gone through the gist of the decision of the Karnataka High Court reported at page 751 of Yearly Digest 99 of Andhra Pradesh High Court. Though the full text of the report of the judgment contained in 1999 within brackets 5 KLD page number 604 is not readily available, the principle contained in the said decision is clear from what has been reported at page number 751 of the Yearly Digest. In this judgment, the Karnataka High Court held that the primary responsibility of collecting Provident Fund contributions from the employees and paying them to the Commissioner is that of the principal employer and not that of the contractor. Therefore, any contributions collected from the employees have to be credited into the code number of the principal employer, whoever collects the same from the employees. The judgment was rendered in the case of Workmen of Bharat Earth Movers Limited versus the management of Bharat Earth Movers Limited and others. There is another judgment of Madras High Court reported in 1999 1 MLJ 350 in a matter arising between Ujjwal Transport Agency versus Union of India, wherein the Madras High Court held that non-payment of Provident Fund contributions by a contractor on behalf of company amounts to default under section 14B of the Act, and furnishing of code number of the department is not a precondition to pay the contribution. Both these decisions make it clear that the code number has to be obtained by the employer for remitting the Provident Fund contributions. So far as this proposition is concerned, there cannot be any dispute for the reason that an obligation is cast upon the employer under section 80 of the Act to recover the employee's contribution of Provident Fund from the contractor under any contract and deposit the same with the Provident Fund Commissioner together with the employee's contribution, and the contractor may in turn recover the amount deducted from his bills from the basic wages, dearness allowance and retaining allowance, if any, payable to such employee. However, the deposit of the Provident Fund with Provident Fund Commissioner by the employer is in respect of these establishments or class of establishment specified by the central government in a notification to be published in the official gazette, while framing a scheme to be called the Employees Provident Fund Scheme under Section 5 of the Act. In this context, it becomes necessary to refer to a few of the provisions in the Act. Section 13A of the Act postulates that the Act, subject to the provisions contained in Section 6, applies to any other establishment employing 20 or more persons or class of such establishment which the central government may, by notification in the official gazette, specify in that behalf. The Act does not contain the definition of an establishment, though a factory and industry are defined. Appropriate government is defined in Section 2A as meaning the central government in relation to an establishment belonging to or under the control of the central government, or in relation to an establishment connected with a railway company, a major port, etc. Section 5 contemplates the central government by notification in official gazette framing a scheme called the EPF scheme for establishment of provident fund under the Act for employees of an establishment to which the said scheme shall apply. Section 5(1)(a) contemplates the vesting of fund and administration of the same by the central board constituted under Section 5(a).